Welcome to Antitrust Matters, a Constantine Cannon podcast where we have engaging and timely conversations about competition policy in the digital age. My name is Jeff Shinder, and I'll be your host. Antitrust has always mattered to consumers and businesses, but today it is also in the public discourse more than ever. From how we get our food on our plates, to how we travel, to the way we interact daily using digital apps and platforms, antitrust touches each and every one of us in ways we may not even realize. In Antitrust Matters, we bring you perspectives of experts and visionaries in the field who discuss where antitrust law has been, where it is going, and why it matters today more than ever before. In today's episode, I'm joined by my partner, David Scupp, and we talk with two key pillars in our firm, our founding partner, Lloyd Constantine, and our chairman, Steve Cannon. Okay, welcome back, everyone, to Antitrust Matters. We have some special guests today. We have Constantine Cannon, Lloyd Constantine, our founding partner and current chair emeritus, and Steve Cannon, our current chairman, two sort of foundational pillars of our firm. We're here to talk to them about their careers, especially their careers in antitrust, the history of the firm, why antitrust has mattered a whole lot throughout their careers, why it especially matters today, and our firm's role, in that conversation. So I'm joined by my partner, David Scupp. Welcome, David. Welcome, Lloyd. Welcome, Steve. We're happy to have you on the pod. And I want to open up with a question to Lloyd, really just get your background pre-Constantine Cannon. What led you to become an antitrust lawyer? What were your travels in antitrust before you founded Constantine Cannon?
Sure. I started out as a civil rights, civil liberties lawyer for the Legal Services Program, representing poor people. And I did that for around 10 years after I got out of Columbia Law School. And in the last couple of years of that 10-year run, I won 3 significant cases, civil rights, civil liberties cases, which in some way involved the state of New York. So I got the attention of people at the Attorney General's office who were defending these cases. And a new liberal Attorney General had come in, a guy named Bob Abrams. And they took notice of these cases and they invited me in to interview. And I said I didn't want to work for them and defend the kinds of cases that I had brought against them. And they said, no, we'd have you do affirmative work. And I said, well, I'm a civil rights lawyer. I'll head your civil rights bureau. They said, well, you already have a head of that. And would you want to be the deputy bureau chief? And I said, no, thank you. I don't want to be anybody's deputy. I've just won these 3 big cases against your office, so I want to run something of my own. And they said, well, the only bureau head that we haven't replaced so far was the antitrust bureau head. And I said, okay, I'll do that. They said, what do you know about that? I said, well, I took the course at Columbia Law School. And it's always struck me that antitrust is sort of the civil rights and civil liberties of the marketplace. Whether I believe that at the moment, I'm not sure, but it was a good line and it was a convincing line. And I convinced the people at the AG's office and ultimately the Attorney General to hire me. So that's how I got into antitrust. And I took my office in late July of 1980. And I stayed there for 10 and a half years as the head of the Antitrust Bureau of the New York Attorney General's office, which was the largest state antitrust office in the country. And during that decade and a half year, something interesting was going on in Washington. The Reagan administration had come in and with a plan to change what had been the traditional enforcement of antitrust as it came from the federal agencies, from the Antitrust Division and the Federal Trade Commission. And they decided to emphasize certain parts of antitrust, but to shut down and de-emphasize other parts of antitrust, which they had traditionally run for the country. That created a kind of a void because the state attorneys general had pretty much played third banana to the federal agencies and relied upon the federal agencies to do that sort of work. When some of the traditional antitrust enforcement stopped, and I'll give you a couple of examples. So, for example, in the area of Section 2 of the Sherman Act, during the entirety of the Reagan administration, there was only one case in which they asserted Section 2 of the Sherman Act involving monopolization, attempts to monopolize, and conspiracy to monopolize. Only one case. And it really was an interesting case involving American Airlines. In another area of traditional antitrust enforcement involving so-called vertical restraints of trade, not a single case was filed by the Antitrust Division during those 8 years. That obviously created and I should say that was done on a principled basis by the federal enforcers. They believed that they were doing what they should do and consistent with the public interest. We disagreed with that. And during that period of time, I pulled together a consortium of the state attorney general's offices around the country and eventually formed a de facto third national agency, which was staffed by the state AGs around the country. And we collectively enforced the antitrust laws during the period roughly from 1984 through the time that I left in early 1991. And in many cases, there were 10 states, 15 states, 20 states, 30 states, 37 states, 44 states, 47 states, 48 states. And on the last day of my job, which was January 7th, 1991, we filed a case on behalf of all 50 states and 5 territories. I believe it was the first time and the only time in American history where all 50 states sued on a single day in a single lawsuit together in the antitrust area. So that's how I got into antitrust. And that is the period before I left the state AG's offices.
Okay, so thanks, Lloyd. So Steve, why don't you tell us where you were when Lloyd was spearheading the states in the 80s?
Yeah.
What were you up to?
Well, thanks, Jeff. And by the way, I'm so delighted to participate in this, and especially with my longtime friend and colleague and special guy, Lloyd Constantine. So long and short of it is, I finished law school in 1976, a little bit south of Columbia, the University of South Carolina Law School, where I'm from. Took a clerk for a year and then took the opportunity to apply to the honors program at DOJ. I'm glad to hear that Lloyd at least took the course at Columbia, the antitrust course, because at South Carolina, they actually didn't offer an antitrust course. However, I was captain of the national moot court team my third year, and that turned out to be an antitrust case, which kind of in some form of a little bit of a premonition was an antitrust case about these newfangled things called automated teller machines. So suddenly I was in the payments antitrust business and didn't even know it. So I applied to the honors program, and I just thought antitrust was the most interesting area of law that I had ever been involved in. So I applied to the antitrust division, and lo and behold, got the offer to do that. So I was a trial lawyer, litigator for almost 4 years, from 1977 to 81, and then being from South Carolina and the chairman of the Judiciary Committee, happened to be a fellow South Carolinian. I found myself as the chief antitrust counsel of the Senate Judiciary Committee. And I think I may have been 28 or 29 at the time. I'm positive I wasn't 30. So it was a very daunting thing to do, but boy, it was a great fun. So I did that for the Judiciary Committee for just about 4 years. And then at that point, Doug Ginsburg, had become head of the Antitrust Division, succeeding Bill Baxter. And Doug called me and asked if I would consider being his policy and appellate deputy. So I did that for just about 2 years, and that was a lot of fun. Then finally, eventually went into private practice. Did that for about 7 years. One of my clients was Circuit City. And after about 7 years, the CEO of Circuit City asked me to come down to Richmond to be his general counsel. So I did that as GC for Circuit City and CarMax. And then suddenly Constantine Cannon kind of came into being. So that's my background to get to the firm. So
I'd like to sort of point out that there's a link between these two backgrounds. So I explained what was going on in the States during the 1980s when Steve was at the Antitrust Division for a significant period of time. I think the first 2 times that Steve and I met were in 1985, because there was a pretty significant disagreement about the law and what parts of the law should be enforced and how they should be enforced. And as the head of the states group, of the multi-state group, I wound up, debating in various forums with people from the Federal Antitrust Division and from the FTC. And often that person was Steve. And we did that any number of times. But we always liked each other despite our principal differences about antitrust law. And I remember one day in particular, which was very interesting. As I said before, one of the areas that the Federal Antitrust Division more or less abandoned was the enforcement of the antitrust laws involving vertical restraints of trade, exclusive dealing arrangements, resale price maintenance, which at the time was per se illegal, and other exclusive territories, things like that. And they not only did not enforce the law in that area, but they actually would go to court and file amicus curiae briefs saying that the law in that area was bad. It should not be enforced. We disagreed with that in the States, and I wrote a set of so-called vertical restraints guidelines that were adopted by all 50 states. It was a different time. There was no Republican AG Association at the time, no Democratic AG Association. There was simply a National Association of Attorneys General, and there was a lot of collaboration on a bipartisan and nonpartisan basis about certain areas of the law: environmental law, consumer protection law, civil rights law, and antitrust law. And I wrote these guidelines. They were adopted by all 50 states, and they were adopted at a meeting in Biloxi, Mississippi in early December of 1985. And I think the very next day, a group of state attorneys general flew to Washington to hold a press conference about these guidelines that had been adopted, and asked for a meeting with the assistant attorney general in charge of the antitrust division, who at the time was Doug Ginsburg. And we were granted that meeting, but when we showed up at that meeting, Doug was not there. Instead, Steve was there, who was the number 2 at the antitrust division at the time. And so that was fine with me. I already knew Steve, and we already sort of liked each other, but it wasn't, okay for the actual attorneys general, including the attorney general of New York, who was there, and the attorney general of the state of Washington was a Republican, and the attorney general of West Virginia, who was a Democrat, a guy named Charlie Brown. And there were a number of others. And so I went into Steve's office to begin the meeting, and the attorney general from West Virginia was just very mad. And he started screaming and stomping around the office and reflecting his displeasure at being downgraded to the number 2, and also about the policy that the antitrust division had at the time in this area of the law. At which point Steve invited him to leave his office. And he said, "Get out of my office. Nobody acts like that. And I remember after the meeting, my boss said to me, can you imagine that this guy Cannon threw the Attorney General of West Virginia out of his office? And I said, I would have thrown him out of my office as well if he had acted that way. So that's my recollection, Steve.
Well, Lloyd, I would be way too polite to say, get out of my office, for heaven's sakes. My mother would never let me get away with that. I just said, General Brown, I understand you, I hear you, but you just really can't act that way. And so, it is nice to see you, but this meeting is over. And that was that. It was pretty polite, Lloyd, you have to admit.
But you were polite.
Okay.
Yeah, you were polite. Anyway, that particular meeting might have been atypical, but it was typical of the strong feeling that was had on both sides during that period of time about how important antitrust was. And we were absolutely certain that in the States that our view of what was important and how it should be enforced and what should be done, we were very, very, very vigorous about that. And there was an equal degree of vigor on the other side in the federal agencies that the way they were enforcing or not enforcing the law was consistent with the public interest. I believe that history, which also has its verdict, has pronounced that the states were correct at that period of time and that the federal enforcers of the time were incorrect. But that, I believe, has been the verdict of history up until now, but history hasn't stopped yet.
So let me get you to start explaining the history of the firm, but I want to put a pin in that to both of you because I do want us to return to the theme of those disagreements and how they resonate to the present in this day where antitrust, at least in the popular conscience, really matters. Always mattered, but it's in front of people. It's a big agenda item in Washington and in the States. So let's come back to that. But let's talk about the firm. I want to throw this to you, Lloyd. You opened up the firm. Tell us about, sort of what led you to that moment. What were you trying to build? Has it realized your ambitions in terms of, this was your baby? Tell us about your baby.
Yeah. So on January 7th, I was lead counsel in this case filed by 55 states and territories against the Mitsubishi Company for vertical price fixing, for a vertical restraint of trade, which was quickly settled by Mitsubishi, paying off the consumers around the country who had purchased price fixed Mitsubishi equipment. And on January 8th of that year, I became a partner at a wonderful firm called McDermott, Will and Emery. I had been brought in, they said, to try to nationalize their practice among their many offices around the country and their London office to try to create sort of what I had done on the state level with their various offices. And I attempted to do that for a few years for a variety of reasons having to do with their clientele. Most of the work of the antitrust work in that firm was on the defense side. And I did a lot of it, and I was perfectly happy to do that. But I was used to also being on the plaintiff side, as I had been in the state AG's offices for 10 years. And I got none of that work. Every time someone approached me to do a plaintiff side case, and I was approached by big companies like General Electric, by American Express, by Visa, to be their plaintiff's lawyer, I always had to say no because inevitably there was a conflict of interest somewhere within the many offices of the firm. And I started to become very frustrated at that. Towards the end of those 3 years, I was approached by another potential plaintiff in a very big and very good antitrust case. And I immediately told that business person that I could not represent them because there was a conflict having to do with some tax and ERISA work that was being done in one of the offices. And at that moment, I realized I would never, ever do the kinds of cases that I had done in the state AG's offices again if I stayed at that very good firm at McDermott. And the conversation between this potential client and I resulted in an idea to start what is now Constantine Cannon. This particular client had wanted me to be his lawyer and had the resources and the money to allow that to happen. And so that was the genesis of the firm. Now, along the way, during those 3 years at McDermott, I had also been contacted by The Limited, which is a huge company selling garments and a retail, one of the large retail companies in the United States, about a potential case. So that was so there was this potential case that this new potential client brought me, and there was this case that The Limited had brought to me during the time that I was at McDermott. But I also, with that case also, I knew that I would never be able to bring that case as a partner at McDermott. So that's what happened. I got this opportunity. This new client provided the capital to open up the law firm and the guarantee of the work that he had. I already had this potential case involving The Limited. And on April 4th, 1994, we opened up a firm that at the time was called Constantine and Partners. And that's how it happened. It was because one potential client wanted me to be his lawyer in a big antitrust case, the kind of antitrust case that I thought I would be good counsel in. And I also carried with me this other case. And a lot of the first few years of the firm of Constantine and Partners, which is now Constantine Cannon, were devoted to these two big cases.
So let me follow up on that before, Steve, because I want to bring you into the story, but I want to ask Lloyd a follow-up that, frankly, I'm naturally situated to ask because I was there shortly after April, not quite on April 4th, 1994. But speak to the kind of the soul of the place that you wanted to build. You set out to create a different kind of law firm.
The law firm that I wanted to build, and I think the law firm that I was successful, I think, in building with your help and with Steve's help and with help of all of our other partners and all of our other colleagues, was a different kind of law firm. I mean, one thing that I wanted to do was to have a firm devoted to antitrust. It was an area of the law that I had that line when I was interviewed by the New York Attorney General in 1980, said I thought it was the civil rights and civil liberties of the marketplace. Well, it was a line at that time, but I grew to believe that and to devote my career to that. So I wanted a firm whose core was and was devoted to antitrust, which I believe is the civil rights and civil liberties of the American marketplace. The Supreme Court has said it's the Magna Carta of the free enterprise system. And I believe that. And so I wanted a firm devoted to that. I wanted a full service antitrust firm. There was no other firm like us at the time. There was no antitrust, small firm which offered everything. We were going to do plaintiffs' work. We were going to do defense side work. We were going to do merger work, etc. There were plaintiff firms that banded together to file copycat cases after a federal agency or a state agency filed a case, and banded together to file copycat cases. But I wanted to sort of replicate what we had done in the States, to have a firm that could do anything. We couldn't do everything, but we could do anything, that we could handle any size of case. So in the two cases that I was talking about before, we went up against some of the biggest law firms and the best law firms in the world with thousands and thousands of lawyers in our little firm. By the end of the first year and a half, the firm was around 7 lawyers, yet we took on cases against firms with thousands of lawyers. So I wanted a firm devoted to antitrust. I wanted a firm that could do the full range of antitrust litigation and counseling. I also had come out of the legal services program, so I was very much still that type of lawyer. So I wanted the firm to operate on a very egalitarian basis. For the first 6 years of the firm, every lawyer in the firm was a partner. when we hired Jeff Shinder, coming right out of the LLM program at NYU Law School. He was a partner on the day that he arrived. Each lawyer that we brought on was a partner on the day that they arrived. After I started the firm, I invited several of the associates who had worked with me at McDermott, Will and Emery, and they were fairly junior associates, but they became partners in our firm on the day that they arrived. So to some extent, it was an expression of my background in the AG's office and my background in legal services. So I wanted a all for one and one for all firm. I wanted a firm that was devoted to antitrust. I wanted a firm that felt that it could do anything. And I think we succeeded in that in the years that followed.
Okay, Steve. So let's talk about when Constantine and Partners became Constantine and Cannon, a name we carry to this day. Tell us about when you joined the story that Lloyd just walked us through.
Yep.
Where do you come in?
Well, it's interesting. The day that Lloyd started the firm in April of 1994 was just about exactly the time that I left practicing here in Washington to become general counsel of a circuit city, and at that time its little small subsidiary CarMax. And so I really not lost contact with Lloyd. We were always friends, but I didn't. We certainly didn't see each other until the day where I was in my office and my CEO came into the office and said, this guy Constantine is right. And I said, oh, well, right about what? And it was all about the case, the debit case that the firm had filed. And I really did not know anything about it at that point. But Lloyd will remember that article that talked about the case and what the implications were for the payments industry. And I remember I said to my CEO, who was a great guy named Rick Sharp, I said, let me make sure I understand this. Oh, and he said, this guy Constantine is right. We got to get in this case. And I said, let me make sure I understand. You want to become a class rep in a major, very large antitrust class case. He said, yeah, I do. I said, well, it just turns out I happen to know Lloyd Constantine pretty well. And he said, great, give him a call and get us in this case. And I did. And Lloyd, what was that, 1998 or so, 7, 8? I can't remember exactly.
It was towards the end of 1996. We filed what became known as the Visa check, master money, antitrust litigation on October 25th, 1996. And you called. There was a big article in the Wall Street Journal about it, and and Rick Sharp reacted to that, and you called soon thereafter. I would say it was early November of 1996. It was one of a number of calls that we got from other companies after that case was filed. The initial 2 plaintiffs in that case were the Limited, the company had come to me back in 1991 with this issue, and Walmart, which at the time was not just the largest retailer in the world, but the largest corporation in the world at the time. So, so you called me in, I think, early November 1996.
Exactly right. And I said, Lloyd, number one, good to see you again. Good to talk to you. But number 2, we want to join your case. And we got together shortly after that. And I guess that was around the same time, Lloyd, you added Safeway, is my recollection, to this?
We added Safeway, we added Sears Roebuck.
Right.
And we added Circuit City.
Right.
And at the time, we had many other very big companies asking to come into the case and become class representatives. So, for example, right after we added Safeway, Kroger said, we want to come in also as well. We were still 7 lawyers at the time, and we were up against firms that literally had tens of thousands of lawyers and handling, large companies like Circuit City and Safeway and Sears Roebuck and Walmart was difficult enough. And I did not want to have more than one retailer in each category. So, for example, with Kroger, I said, you cannot become a class representative, but we will make sure that you are aware of exactly what's going on. And we will always consult with you since you will be a member of the putative class. So at the time that you called, I was getting many Home Depot called. There were many such calls. But I was very, very happy that you called, because to me it was a kind of quality certification. When I got calls from the general counsels of Sears and Walmart and Home Depot, et cetera, they were great lawyers, but they weren't antitrust lawyers. Having you call me was a special thing because you were a major antitrust lawyer, one that I respected, one that I knew what was going on. And so that was, for me, a type of confirmation and quality certification of the firm, of this new endeavor. And so it was a happy day for me.
Yeah. And, from my side of it, it was so excited to, here I was, I very much enjoyed being general counsel, but when you have that job, the emphasis on general, because you have a million things that you're in charge of, that you're responsible for, and it's pretty broad and not terribly deep on occasion. And here with this case with the firm, with Circuit City as a class rep, I suddenly found this great way to get back into what I really did love and enjoy, especially which was antitrust law. So as much as Lloyd may have been happy that I called, I was probably even happier that suddenly I found myself into this. And I must say, once I did do that, and I started really understanding the firm, the makeup of the firm, et cetera, I just thought, who are these guys? How are they litigating this incredibly large case against all these firms and doing it exceedingly well? And that's where I met Jeff, our moderator today, because Jeff had just joined not shortly, just very shortly after Lloyd had opened the doors, and the rest of the legal team. And I have to tell you, at the time I was dealing with had a lot of other lawyers doing a lot of other things, a lot of big firms. And I just was more impressed with Constantine and Partners than I think with anybody else that I was dealing with. And it was, I guess we finally settled that, 3 or 4 years later, something like that. But it was so much fun and very rewarding, actually, to be able to be in the middle of this great antitrust case. So
Steve has exhibited the old platitude that when you're having fun, time flies. But in fact, the case settled on April 28th and May 1st, 2003, 7 years later. It seemed like only 3.5 years to Steve, because although he was a great client, he wasn't in the trenches doing all of the work. But it was 7 years of work.
7 years, wow.
7 years.
Well, it did go pretty quickly.
Right. As I said, it took 5 years to get the case from being hired by the Limited into court on October 25th, 1996. So the settlement came 12 years after we began working on it. But it must have seemed like a short period of time to Steve.
Well, it did. And as you can tell by this interview, Lloyd is very much a precision guy when it comes to dates. Sometimes I feel like I am really good when I get it into the right decade. But this is yet one more impressive attribute of Lloyd Constantine.
Of course, Steve will remember the date in the October 1986 term of the United States Supreme Court, where we were on opposite sides of a case where Steve argued amicus curiae for the United States against the state of New York in a case. And I was lead counsel for the state of New York, and Steve was amicus curiae for the United States. And he was asserting the importance of the antitrust laws, and in particular, the importance of vertical restraints of trade, which was pretty interesting. And that day, that was early October 1986. And in the courtroom, it was the first week that Justice Scalia was on the bench. It was the very week that Doug Ginsburg was appointed to the DC Circuit. And Steve and I were there, and we were all very much involved in this antitrust case. Justice Scalia, Doug Ginsburg, and later Judge Ginsburg, Steve Cannon, and Lloyd Constantine. And there was a moment during that argument when Justice Scalia posed a question to Steve Cannon where all four sets of eyes met. And that was probably the most interesting moment in my entire legal career, where four different people were all thinking exactly the same thing, and our eyes all met at exactly that same moment.
Steve, do you remember that moment?
Yeah, when you're in front of the Supreme Court, at that point, you're not really worried that much about winning or losing. You just don't want to look stupid. So, yeah, I do remember that moment, crystal clear. But and Lloyd and I actually have pictures of us on the steps of the Supreme Court after that. He in a really nice blue suit, and I had my morning coat on that fit pretty much off the rack of the Solicitor General's office. They keep a whole rack of morning suits. And yeah, it's kind of hard to forget. That was extraordinary, Lloyd, wasn't it?
Yes, it was.
Yeah. So Steve, so let's talk 20 years later, approximately 20 years later, after the story you both are talking about, we join the firm and we become Constantine Cannon. We open up an office in DC. Tell us about that decision, the office that you've built in DC.
Yeah.
And your experience now that you are on the inside, to quote Lloyd, in the trenches.
You know what? I had this advantage in terms of a decision on that, Jeff, because it's kind of like that commercial, like I like the razor so much, I bought the company. So here I knew the firm. I knew it inside and out. Lloyd had been more than you guys in the trenches more than I had, obviously, but I was happy to watch you in the trenches. But I felt like, that when it came to thinking about practicing law, if I ever wanted to do that again, I have to say that with respect to the many, many great big law firms that were around and, I guess probably could be possibilities, that just did not really attract me at all. And I really hadn't thought about going back. I had really thought that I would probably stay at Circuit City or go to another company as GC, et cetera, kind of for the rest of my career. It was about probably a year or two after we had settled the debit case. I know Lloyd will correct me with the exact date shortly, but it was somewhere around then. We were having lunch in New York. It's a little disputed whether or not I raised the possibility or he did. I think we have probably different versions of that. At this point, it truly doesn't matter. But we started thinking about the idea of, wait a minute, what do you think about leaving, Circuit City and CarMax? And I've always really wanted to have a Washington office. You're kind of a Washington guy. You've got the right background. What would you think about that? And I think that's the way it happened, Lloyd, but you'll correct me, I know, if I'm not quite right. But we started thinking about it, and then kind of the interview process, talking to all you guys, I'd probably talk to you, 100 times over the years. So that's really how we started. And in fact, in terms of any sort of decision about a career, legal jobs, et cetera, it's probably the one that I was the most confident about that I've ever had. It's very rare that you can go to an organization to become a part of and you know it so thoroughly before you go. So I thought, you know what, the debit case was incredible. I knew of the other cases that the firm had done. And I just thought, this is going to be a lot of fun. It's going to be exciting. And with Lloyd kind of as our leader, I think this firm will remain on the cutting edge of antitrust litigation. And that was only 17 years ago. So I am kind of a newcomer to the firm, but that has turned out to be exactly the case. So,
and Steve's recollection is correct and precisely correct. All those conversations occurred in 2004. Now, that was in the wake of the settlement of VisaCheck master money antitrust litigation, which I should say was reported by both the district court and by the Second Circuit as the largest antitrust settlement in United States history then and to this day. It involved an explicit cash payment of around $3.4 billion and an injunction which the circuit and district courts valued at upwards of around $87 billion just in the first 10 years in terms of savings for American stores and American consumers. At this point, it's far exceeded that extraordinary level. Now, in 2004, we were still sort of basking in the afterglow of that. We had recently then been retained by Morgan Stanley to represent them. They owned the Discover payment card network, to bring another case against Visa and MasterCard. Something else had happened that year. Because of the success in the VisaCheck litigation and this biggest, case in history. In fact, the district court said it was the biggest civil settlement in American history, not just in antitrust. But because of that, 3 large national firms took a run at us and asked to acquire us, to take us over. And they guaranteed us that all of us would make a lot more money, that they would pay our partners much more than we were currently earning. And we said no to all of those offers. We wanted to stay independent and to have the type of firm culture that we had built together. But one of the things that we thought we needed was a presence in Washington. And so on the day that Steve and I talked about this, it was perfect. It was not, almost perfect. It was perfect. I knew Steve. He knew me. We trusted each other. We had this experience. He was strong with the federal agencies. I was strong with the state agencies. He was a Republican. I was a Democrat. There were lots of reasons that this was a perfect idea, and then we made it happen. One of the things about being small is that you don't need to talk to 1,000 people before you do something. I simply brought the idea back to my colleagues in New York. Everybody, each and every lawyer in the office, interviewed Steve, and we were of one mind that this was a great idea. So that's what happened. And that case that I referred to involving Morgan Stanley and the Discover Network, we litigated that, and many years later, and 7-8 years later, we settled that, and that I think was the 3rd largest antitrust settlement in American history. So the story continued, but we stayed independent, and we built it from there when Steve opened up the Washington office on January 1st, 2005.
And, Jeff, I would like to say, I think it's true, and maybe Lloyd will contradict me or not, but we also thought that just the fact that, I had a corporate background, that I had been in-house as general counsel at a big company, that would actually give us some additional credibility in that community. And whether or not we were going to serve as plaintiff's counsel or defense counsel for that matter, it would be helpful, and it would help us kind of span that gap. And as Lloyd said earlier, some of the other firms that are wonderful firms that do incredibly great plaintiff's work, they just didn't really kind of have that ability to make that reach. And so I was thrilled to do it. I'm as thrilled today as I was then. And it has been just a terrific match. So
tune in next time as we continue our discussion. Thank you for listening to Antitrust Matters. That's all for our show today. If you like the podcast, make sure to subscribe to Antitrust Matters and leave us comments on how we were doing or on the topics you would like us to cover going forward. You can also follow us on Twitter at CC Antitrust or follow the Constantine Cannon Antitrust team on LinkedIn. Until next time, be well and remember, antitrust matters.